Like other contracts, arbitration agreements are invalid if executed under economic duress or undue influence. In Martinez-Gonzalez v. Elkhorn Packing Company, the Ninth Circuit considered whether a worker signed an arbitration agreement unwillingly. Dario Martinez-Gonzalez, whom we'll call Gonzalez, lived in Mexico. He supported several family members. Elkhorn Packing Company hired Gonzalez as an agricultural worker in California. Elkhorn paid 5 times as much as Gonzalez earned in Mexico. Elkhorn helped Gonzalez obtain a visa and provided him transportation and housing. After starting work, Gonzalez and 150 other workers had to sign employment paperwork at an employee orientation. The orientation occurred at the end of the workday in the parking lot of the hotel where the workers lived. At each worker's turn, an Elkhorn representative flipped through a package of documents and indicated where to sign. Elkhorn encouraged workers to hurry so others could sign too. The documents included an arbitration agreement written in Spanish, Gonzalez's native language. Elkhorn didn't explain the agreement to Gonzalez, didn't tell him that he could consult a lawyer before signing it, and didn't give him a copy. Gonzalez signed the agreement without reading it. Halfway through the season, Gonzalez quit his job and returned to Mexico. Later, Gonzalez sued Elkhorn, alleging state and federal labor law violations. Elkhorn moved to compel arbitration. After a bench trial, the district court denied Elkhorn's motion, finding that the arbitration agreement was unenforceable because of economic duress and undue influence. Elkhorn appealed to the Ninth Circuit.